Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Here are the headlines. Manish Sisodia's bail plea rejected by the Supreme Court in Delhi liquor policy scam case. Attorney General refutes challenge to electoral bond scheme, says citizens don't have a right to information for knowing details of funding of political party. Parliamentary Standing Committee does not adopt draft report on 3 new criminal bills, likely to meet again on November 6th. Kerala High Court amends rules for designation of senior advocates. Delhi LG accords sanction to appeal before the Supreme Court against Delhi High Court, allowing acquittal of 12 murder accused in the 1984 Anti-Sikh Riots case. Minister of External Affairs meets families of 8 Indian Naval Officers sentenced to death in Qatar. Assures case will be prioritized. Now let's take a detailed look on the headlines. The Supreme Court today rejected the bail plea of Aam Aadmi Party leader and former Deputy Chief Minister of Delhi, Manish Sisodia, in the Delhi liquor policy scam case. A bench of Justice Sanjeev Khanna and Justice S.V.N. Bhatti made the order against Sisodia for alleged money laundering and corruption by way of framing the liquor policy in Delhi that now stands repealed. The case relates to irregularities committed while modifying the excise policy to extend undue favours to licence holders. Sisodia has been in custody since February 26th, and the cases are being investigated by the 2 central agencies, Central Bureau of Investigation and Enforcement Directorate. Justice Khanna, while pronouncing the verdict, assured that though the application for bail is being dismissed, the trial will be concluded within 6 to 8 months, and if the trial proceeds slowly or sloppily, Sisodia will be entitled to file an application of bail within 3 months. The Attorney General of India, R. Venkatramani, in his submissions made to the Supreme Court, whose constitution bench is going to consider the challenge to the electoral bond scheme starting tomorrow onwards, refuted the claim of the petitioners. The AG submitted that the citizens do not have the right to information under Article 19, Clause 1A of the Constitution of India to know about the funding of a political party. The AG further said that there can be no general right to know anything and everything without being subjected to reasonable restrictions, and that the right to know as necessary for expression can be for specific ends or purposes and not otherwise. The Supreme Court's Constitution bench, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice Sanjeev Khanna, Justice B.R. Gavai, Justice J.B. Pardiwala and Justice Manoj Mishra, are set to hear the batch of petitions that challenge the electoral bonds that were brought by the amendments through the Finance Act of 2017. The petitioner alleges that the electoral bond scheme is not transparent and is in fact an obscure funding system which is unchecked by any authority. Notably, electoral bonds were introduced in 2017 and implemented in 2018 as a means for individuals and entities to make donations to registered political parties anonymously. The State Bank of India is the only authorized issuer of these bonds, and it can only be purchased in favour of political parties registered under Section 29A of the Representation of People Act, and that have secured at least 1% of the votes polled in the last general elections of the Lok Sabha or the Legislative Assembly. The Parliamentary Standing Committee, responsible for the scrutiny of 3 new criminal bills that seek to replace the existing colonial-era criminal laws in India, did not adopt the final report during its meeting on October 27th. The draft reports were not adopted as was initially planned due to the request made by opposition members for additional time to examine the bills thoroughly. The committee is now likely to meet on November 6th for further discussions. The bills seek to replace the British-era legislations, namely the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, and the Indian Evidence of 1872, with Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam respectively. Complying with the Supreme Court's judgment in Indira Jaising vs. Supreme Court of India, the High Court of Kerala made amendments to the rules for designation of senior advocates. Amendments were made to the High Court of Kerala Designation of Senior Advocates Rules of 2018 with several changes like a minimum age bar, minimum experience criteria. The minimum age prescribed by the new rules for designation as a senior advocate has been fixed as 45 years, while the minimum experience criteria of at least 10 years of practice as an advocate has been prescribed as per the amendments. A point-based system for evaluation of proposals were also made. A committee has also been prescribed for the designation of senior advocates, which shall consist of the Chief Justice as its chairperson and two senior-most judges of the High Court, Advocate General of Kerala, and a member of the bar nominated by the chairperson and other members. Among these many other changes, like setting a time limit for reconsideration of proposals and grant of power of full court to designate senior advocates suo motu were made. The Lieutenant Governor of Delhi V.K. Saxena has accorded his sanction to the prosecution to appeal before the Supreme Court against the judgment of the Delhi High Court, wherein it allowed acquittal of 12 murder accused in the 1984 Anti-Sikh Riots case. 8 persons were killed and 1 was injured in the Nangloi area of West Delhi due to the incident. The LG has given his approval to a proposal from the Home Department to file a special leave petition in the top court, with the aim of contesting the High Court's judgment passed on August 9 this year. This particular judgment had rejected an appeal against the trial court's verdict, which had previously acquitted all the accused. The High Court's rationale for dismissing the appeal was based on 2 key factors. Firstly, it cited an excessive delay of 27 years in filing the appeal against the order of the trial court, which was issued on April 25, 1995. Secondly, the High Court determined that the grounds presented by the state were not sufficient or justifiable. In response to this, the Home Department filed a proposal before the LG to seek approval for filing an SLP before the Apex Court. The proposal mentioned that the Supreme Court on January 11, 2018, in a writ petition titled S. Gurlar Singh Kahlon vs. Union of India, has issued directions to constitute an SIT for further investigation of 186 cases related to the 1984 riots, and the present case is part of these 186 cases. S. Jaishankar, the Minister of External Affairs for India, met the families of 8 Indian Navy officers that were sentenced to death by a court of first instance in Qatar on charges of espionage last week. The 8 Indian nationals were arrested by the Qatari intelligence agency on August 30, 2022, for spying for Israel in relation to a submarine program. However, the charges against them were not disclosed. Mr. Jaishankar said that India is exploring all legal options and the matter is placed at highest importance. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.